I'm Lynn St. Louis. I am the founder of Elder Law Group, ELG Estate Planning Lawyer. We are talking about the 5 biggest estate planning mistakes and how to avoid them. Mistake number 1, not designating accounts to pay to your intended beneficiaries. So, a key purpose of an estate plan is to make sure that your assets go where you want them to go, to the people that you want to receive your assets. Estate plans can do a lot of other things, include protecting you from taxes and losses, etc. More about that later. But the mistake that people make is not understanding their assets and understanding what they need to do to direct their assets. Now, why is that? The reason for that is that people think that their will covers all their assets. Wrong. Your will does not cover all of your assets. What a will doesn't cover, what a will doesn't address, are what we call non-probate assets. That would include like your IRA, your 401k, your annuities, your life insurance policies. All of those are considered non-probate assets. And when it says non-probate assets, what that means is that your will doesn't cover those assets. When I say it doesn't cover it, that means your will is not going to direct where those assets go. Those assets need to pay by way of a beneficiary designation form. That is a form that you fill out with your financial advisor or with the financial institution that holds the asset. So a lot of times people just overlook it. They don't think about those assets, and then they don't address them. And that's where the problem comes in. So if you have, for example, a do-it-yourself form, an online form for your will, you probably just fill that out. You may even follow the formalities of having it notarized so that it actually is a valid will, but it's not going to cover perhaps your biggest asset, your IRA, for example. You're not going to know that. You're not going to know that because you haven't met with an attorney that's described and explained this to you. The forms aren't going to help you do that. So one of the things that's really important to understand is that certain of your assets must have a beneficiary designation form completed correctly, filled out, and with a financial institution. And that way you can ensure that that asset goes where you want it to go. So let me give you a couple of examples of things gone wrong. This is a situation where I actually did a probate for this gentleman after his death. His will, which was completed by another attorney, and this attorney was not an estate planning attorney, said, I want my retirement account to pay to the trust for my grandkids. And this gentleman's retirement account was his biggest asset. He was in his 70s and he had recently married. Well, unbeknownst to him, and the attorney, who was, again, not an estate planning lawyer, a general practitioner who had prepared his will for him, they didn't talk about the need to change his beneficiary designation. So what happened? Well, his retirement account was a 403B. It was with TIAA CREF. And what happened was the document that plan itself said that on the death of the account holder, it would pay to any spouse. He had just gotten married 2 years before his death. He'd accrued all of this money over many, many, many years. But because of what the plan said, and because he didn't understand this asset and his lawyer did not help him out, what happened was when he died, the biggest asset of his estate went to his brand new wife and not to his grandkids. Not at all what he wanted. So that is really one of those examples of, what can go wrong. It went wrong for him. Another example, let's say that you have a 401k and that you get a divorce. And before you were divorced, your 401k said, hey, it pays to my ex-spouse, or to my spouse at the time. After your divorce, it's your ex-spouse. Let's say you change your will and you say, ex-spouse, you get nothing. but you didn't think to change the beneficiary designation on the 401k. It still is paying to that person who is now your ex-spouse. And again, it can be your biggest asset. What happens? When that person dies, the 401k will pay to the ex-spouse, regardless of what the will says, regardless of the fact that this person absolutely would not want the 401k to pay to the ex-spouse, but because the person didn't change the beneficiary designation, that's the outcome. So there can be some really serious consequences that happen in somebody's estate planning if they don't take care of their beneficiary designation. So what should you do? Number one, you should talk to an estate planning lawyer. That example I gave you about the gentleman whose grandkids got nothing, he had his will done by a general practitioner. If you talk to just about any lawyer, they'll say, I can do your will, because they're not thinking. They think the will is just this simple document. They're not thinking about the estate plan and all the complexities and something, what an estate planner would think of. That's why there was such a bad result with that gentleman whose grandkids got nothing. You should also talk to your financial advisor in the financial institution that holds your assets, because the financial institution, they're the ones that have the forms that you need to complete. And I have to tell you, forms at every financial institution, they're all going to be completely different. So you're going to need to say, I need help filling out those forms in a way that the financial institution will accept. The lawyer can give you guidance to say, you want it to pay to your spouse, you want it to pay to the trust for your spouse, you want to pay to the kids, whatever, but you do need to fill out those forms. And if you don't fill out the forms, that account is not going to pay where you want it to pay to, and that's going to frustrate where your estate plan is.